My name's Elaine Willman, and I'm standing in front of Mr. Lawrence Kogan, Larry Kogan, from New York. Larry represents some property owners on the Flathead Indian Reservation in issues we're having with federal Indian policy, and specifically with the recently state legislature approved Confederate Salish and Kootenai Water Compact. But before we start, and before I turn it over to Larry, I'd like to share a couple things. One, federal Indian policy is a whole combination of government decisions. And the reason I stress that is because everything I study and read and speak on is a specific government decision. It is separate from, in my heart and soul, because I'm Cherokee and my husband is Shoshone, it is separate from a lifetime respect for American Indian history, my own ancestry, my husband's ancestry, my respect for all cultures, certainly American Indian culture, is one thing. Government decisions are another thing. And I had to do that very personal sorting when I first got into these studies, when I lived on the Yakima Reservation for 16 years. And then more recently, I lived on the former Oneida Reservation in Wisconsin for 8 years. And now I'm here in Ronan on the Flathead Indian Reservation. And I can tell you, when I first moved up to the Yakima from Southern California, I was probably what you would call one of those California, well, I won't say liberal, but I was sort of liberal then, and I just couldn't wait to get up and go to work for the city of Toppenish, Washington, because I was going to be on a real Indian reservation, and I worked very hard to have a good rapport, and did have a very good rapport with the Yakima tribal leaders for many years. And then not long after they got their casino, because on that particular reservation, it's almost 80% Hispanic, 10% Anglo, and 10% American Indian. A big farm, ag country, irrigation systems and districts like here. And there was a really good live and let live among all the cultures there. The 4th of July parade in Toppenish, Washington is Americana at its best. The American and Indian princesses and the drummers and dancers, and you have the Hispanic mariachis and dancing horses, and you have the farmers with their big hawk machinery and what. And the 4th of July parade in Toppenish is Americana. All the cultures get along. And then about the time the Yakima tribe got its casino, it's like the kids that all grew up together and got along together, it's like we woke up to a whole different neighbor. And suddenly the tribal government there, not the people, the tribal government there was wanting to ban alcohol on the reservation. That would have shut down 47 beautiful wineries in the communities on the reservation, and tax our utilities and one thing and another. And that's when I had to start doing the personal sorting, because I can't go I have no voice in the tribal government. They're not supposed to have any authority, and do not have any authority over me as a non-member. And that was a government decision that got my attention. It got me into this, and I've not been able to let it loose since. I've got a lot of tribal member friends on all 3 reservations, because this is not about the tribal members. This is not about the culture. This is about decision-making that is federal Indian policy. And it comes from Congress, and it used to come just from the Bureau of Indian Affairs, and now it comes from all 29 federal agencies, times 566 tribal governments, and 326 reservations across the United States. And if you think about the 50 states, you can see them in your mind right now. You know what the shape and size of all the states are. Upon their statehood, they have a fixed boundary. They have finite resources in that fixed boundary. Those states will never grow. They're there, Washington, Oregon, Idaho, Montana. They don't grow. But then if you imagine tribal governments and reservations, 31 in Washington State, I think 9 were in Oregon, 9 or 11 or something like that in Idaho, 7 here, going on 8, I think. These are separate governments, separate jurisdictions, co-located in the states, within counties, within towns and cities that do grow. And if you can just take a wild guess at Washington State, how 31 tribes have really overwhelmed Washington State, it starts raising up some deep, deep issues for all of us, for all of us. So what we're going to be talking about tonight is this growth. And I'm going to say that this growth is not always initiated by a tribal government. Currently, the federal administration is encouraging the expansion of tribal lands, tribal governing authority over non-members. They are rolling out with some big stuff, all 29 agencies. And so we are in this dilemma, especially in the western states. I'm going to say especially in the western states. There are a number of agencies, not just the Bureau of Indian Affairs, but the Bureau of Land Management, the Bureau of Reclamation, USDA, Fish and Wildlife. All these federal agencies are expanding the federal footprint out on states and replacing state authority and state jurisdiction and state protections over its people, over its citizens. So what's happening in the western states is water, because water is land. Water leads to the control of land. And that is happening in Klamath. Mr. Kogan will talk to you about the Klamath situation. That's happening in Idaho. Idaho is one state that is protecting itself and doing a really good job. That's happening in Northern California. It's happening quite seriously here in Montana. This Salish-Kootenai Compact is quite different than 6 other compacts. One of the things that will happen if this compact is ratified is that 6 other tribes will ring up the governor's phone and say, you have to treat us the same. We want to modify our compacts. So if this one tribe in the western states acquires 100% access to all waters, 6 other tribes would say, we want ours. We want all our off-reservation stuff. And in no time, Montana's state waters are entrusted by the United States for the use by the tribes. And the rest of Montana's population is secondary and subservient to and dependent upon governments you may not enter or vote in for your supply of water. And in the Flathead, it's even more so because the tribal government, Bureau of Indian Affairs, also owns and controls Mission Valley Power. So our dilemma on the ground tonight that we're talking about, even before this compact is ratified, our dilemma is this. We have a federal government and tribal government that has 100% control of all access to water, from the dam, through the rivers, maybe through the irrigation system. We just pray. But they have 100% control, the federal government and tribes, 100% control of access of water right now, whether or not the compact passes. On the reservation, every human being that lives within the reservation, the tribal government, these are government decisions, the BIA owns the Mission Valley Power operated by the tribe. They have 100% control of all access to electricity. Now it takes water and electricity for livelihood on the land or not, or for the economy of the communities and counties or not. That's our present circumstance. Water and power is completely out of our control right now. Now here's the other thing. For all the people that live, tribal members as well, tribal members and others who live on the Flathead Indian Reservation today as a direct result of the compact, we don't have a government we can turn to for help. We cannot turn to the federal government. Our state government has utterly abandoned its authority and protections and walked away and thrown in 55 million taxpayer dollars on top of all the state waters they're donating. You know, we don't have a federal government, not a state government, not a county government or a local government. Our county and local officials are first extremely uninformed, second scared to death of being called a name, spineless, uninformed and spineless local, municipal and county elected officials who are afraid to not go along to get along. So that's our condition. The citizens on the reservation today do not have a government they can turn to, not one. And we have no say over the rates or how much it costs or whether or not we're going to get any water or electricity. There's something fundamentally wrong with those decisions. They're very, very serious, actually life-threatening decisions. And that's why, well, here's the other problem. There isn't, and this happened in Washington State too, there isn't a single Montana attorney who has offered to step up and help the property owners, the irrigators, the farmers, the businesses that are affected by this. Not one single Montana attorney will step up and say, how can I help? Not one. In Washington State, I lived there for 16 years, and when things got sideways and you needed legal counsel, you couldn't find a Washington attorney that would help you go, you know, confront the federal government decisions or tribal government decisions. They would all say, oh, we have a conflict of interest. The 31 tribes spread their caseloads across the major attorneys in Washington State. So if you're in Washington State, you have to get an out-of-state attorney. If you're in Oregon, you have to get an out-of-state attorney. And I discovered it's the same thing here in Montana. We couldn't find one, not one. There was one before I got here, and he passed away, and they lost him. And it was Lloyd Ingraham. And I didn't have the chance to meet him. So that's why the search was on for an attorney with knowledge on treaties and international law and federal Indian law and water law. And so we have formed a team, and Mr. Kogan is now representing the property owners. So with that said and that background laid, I want to thank you all for being here. Oh, one other thing, I want to thank Carol Lyons and Sheila Alejo and Laura O'Neill and Clarice Bryan and all the folks that have helped us pull this week together. We're sort of on a dead roll this week. Mr. Kogan is doing a lot of fact-finding, and then he's also doing a lot of visiting with people. So with that introduction, I will turn it over to Larry, and thank you.
You've got a number of different subject matter areas that are at play at the same time. You have federal state government dynamic going on. You have a state local government dynamic going on. And now all of a sudden you have a tribal, state, local, federal government dynamic going on. And when you look to see how those governments are supposed to interact with one another, you have to look for some guidance. Since we are a country based on a constitution, and that constitution sets forth in its articles the relationship of government to the individual and the various branches of government to each other and to the individual, you have to take a look at where the tribal government part of the dynamic fits in. And if it does fit in, to what extent does it displace any other dynamic? I would argue, based upon the sovereignty claims of federally recognized tribes and the policies instituted by the federal government through its many executive agencies, that the pursuit of tribal sovereignty and self-governance and self-determination is slowly eroding the other areas of state and local sovereignty. Now, this is not in isolation, though it has been going on in this country for at least 40, 45 years, or longer. Beginning with the Indian Reorganization Act of 1934, the positioning of the ownership of land between tribal and non-tribal members, the reversing of congressional policy, and the effect on individual land and water right interests. That's occurring on the national and state and local stages. But really, in today's world, you also have to look to the international. And unfortunately, what occurs internationally it does eventually reverberate domestically. A case in point, the United Nations Declaration of the Rights of Indigenous Peoples. Simply a political declaration. Perhaps in some cases a heartfelt political declaration by governments around the world that sit in that United Nations venue. A political declaration that isn't at a level of legal enforcement until a national government, which is a member of the United Nations, decides to take it to another level. The administration, the prior administration of Bush 43 did not find that that declaration, were it to be implemented as law domestically, would be in the national interest. The Obama administration, to the contrary, has taken the opposite position. It believes that it is within the national interest of the United States and has provided a signing and implementation statement to show how far the United States government is willing to go to provide federally recognized tribes with the indigenous rights that are identified in that declaration. Interestingly, it specifies Klamath region. It also talks about a scenario not unlike the Flathead area. And essentially, if you read it and go through the different paragraphs, it wishes to restore the Aboriginal lands and waters to the federally recognized tribes as an expression of federal Indian policy. Now, again, if we go back in time, federal Indian policy is an effort to provide restoration to the tribes as the result of the treatment that they suffered at the hands of bad congressional policy, or really maybe not bad policy, but bad implementation of policy. In Washington, you have to distinguish between the two. And unfortunately, it's gone way over the neutral barrier and not only reversed questionable policy of Congress, but have taken the rights of those who depended on that policy in the past, who put their blood, sweat, and tears into the land and made a desert into a fertile area. Now, of course, the federal government was there with the irrigation project, with the Newell Tunnel and the Kerr Dam to help take an otherwise arid area and make it fertile. And yes, the irrigators, including yourselves, paid for that. There were repayment contracts that evidenced that obligation. And through the payment of those monies, irrigators were to, for instance, own and manage and control that irrigation project after it was fully paid off. Operation and maintenance costs were to be treated as annual costs, not capital costs. The dam that was built based upon the investment of the federal government, which was then supplemented by the licensee, those net power revenues were to go to the cost of the project and to the cost of the dam to replenish it. But in the interim, and in the course of that process of domesticating the wildlands, so to speak, you have a situation where the federal government had to reserve the ability to use the water that properly belonged to the state. Under constitutional equal footing doctrine, a territory that becomes a state assumes the land and water rights of the 13 American colonies so that everybody is on equal footing. Because back then there were no federal lands in the 13 colonies. So what we have is a federal reserve of water rights to the waters of the Flathead River. And those water rights were filed in the early 20th century, I believe sometime between 1915 and 1920. The reserve rights were consented to by the state of Montana pursuant to legislation enacted in 1902. But that's just part of the story. You also have reservation lands and waters. How did the reservation come into being? It came into being as a quid pro quo, assuming the form of a treaty that the Secretary of the Army, or Secretary of War at that time, had entered into with the tribe. the CSKT. In exchange for the presentment of Aboriginal lands and waters, the tribe received a fixed reservation with boundaries. Thereafter, in the early 20th century, and that occurred in 1855. Thereafter, there was Supreme Court jurisprudence that interpreted the land rights that they had as requiring water to service those land rights, the Winner's Doctrine. But it was only as much water as was necessary to service the objective of the reservation. But Congress wasn't satisfied with taking what it had created through treaty and changed its policy. It started to enact laws that wanted to settle the West. One of the policy agendas of that was to avoid the British from coming down in from Canada. They wanted to settle the West rather quickly. Having faced the British in the Revolutionary War and faced the British again in the War of 1812, they certainly didn't want to have another scenario where they would be exposed, so they obviously thought very deliberately about settling the West through general allotment, Dawes Act, homestead, mining concessions to get people out there. They had to give them some type of incentive. And this wasn't exactly an easy transition for people going out into an untamed land. I think we all know that. But the point is, those policies provided, they serve two purposes. One, they settled the land in order to prevent a foreign sovereign from delving in and upsetting the United States again. But two, they also tried to reaffirm what the founding principles of this nation were among the settlers who were out there. This was still the United States, even though it was a territory. And those founding principles included the right to property. In fact, James Madison once said, a person's right to property is no less than his or her property in his or her rights. Okay, and that was in the National Gazette, I think, in 1797, I believe. But I may be corrected, and I have the documentation to show it. But the point is that with property rights, people were free. It provided economic freedom, it provided political freedom, and it also provided government accountability. That was American culture, and it still is American culture, notwithstanding efforts of those to change it. Now, part of, should I say, welcoming the Indian community into the United States population is to give them the opportunity, or was to give them the opportunity to own and work the land, just like the other American citizens, no matter from where they came. And our country is a country of immigrants. And we are one of many, and many into one. Cultures, religions, ways of life, etc. The Indian cultures are, in many ways, similar. They're not necessarily a monolith. They're a combination of cultures themselves. The CSKT is no different. But the fact is that in exchange for an allotment in fee title of land, the tribal members could be full citizens of the United States and enjoy all of the protections and benefits afforded by the U.S. Constitution, which, as you know, recognizes our natural rights under God. So, the assimilation policy, or should I say the Americanization policy, or should I say the constitutional property rights policy of the federal government at that time, was to provide allotments, fee allotments individually to individual tribal members so that they could enjoy the same fruits and benefits as other members of the American public, other citizens. Now, the tribal members, either individually or through the tribal government, had the choice of whether to participate in that process. Some chose, and others did not choose to participate. The problem here is that over time, it had been proven that maybe the policy was not implemented properly, and the well-intentioned policy, which was to afford the tribal members the ability to share in the American dream at that point, which was to own land and to be able to farm that land in order to become independent individuals. I mean, remember, our nation was built on the founding principles of humanism in the Enlightenment era. They were not able to make good, and unfortunately they had to sell the land, and less than market rate prices. But again, this is an unfortunate outcome in many government policies, and it continues today. And what we have here now, beginning with the 1934 Indian Reorganization Act, was a reversal of that policy. So with Congress legislating a certain outcome, we have executive authority in the executive branch of government through presidential proclamation or secretarial proclamation, reversing that policy. The question is on what legal authority? Okay? And that reversal continues until this day today. And it's been much enhanced since then, because now, through many years of White House policy of restoring what is believed to be pre-constitutional Indian sovereignty, we have a situation where the sovereignty of federally recognized tribes, which is all but dependent, or actually all but independent, is displacing the role of states in imposing legal order and in protecting property rights. Now, the question is, on what basis are they taking these actions? Federally recognized tribes have been afforded greater sovereignty and self-determination in order to make them independent of the government fisc. That was the stated policy by a number of presidents. But in reality, that has not occurred. Instead of enhancing their welfare, they just enhanced welfare. They made them dependent sovereigns. And if you keep on getting lots of money from the federal government, you only become more dependent. And you don't go out necessarily and work for it yourself. But there are cases in point where that is not the case. Okay, there are certain tribes that are very industrious, and they enter into contracts with the government, and they make lots of money from those contracts. They do good, in other words. There are other tribes that depend on the welfare and just wait for it to come in. The Klamath tribe, for one, is one such tribe, and they are described as a welfare tribe. The CSKT, on the other hand, is an industrious tribe. It has 13 subsidiary entities, from what I can gather, that are engaged in all types of business. They hire many skilled people from different industries. That doesn't mean that they can't do it themselves. They maybe know how to hire to do it. But the question is, where's all the money going? Okay, one of the things that we looked at when we challenged the transfer of the Kerr Dam in early September of 2015 was, what does this tribe do that entitles it to the title of a federal dam? And are those monies, those U.S. taxpayer-spent monies, being wisely spent to afford all the members of the tribe the benefits that were intended by either the congressional appropriation or by the contracts? And what we found is, by speaking to a number of members of that tribe, that there is a disconnect between the tribal government and the tribal members. Now, we can't say, knowing what we know today, that there isn't a disconnect between our federal government and we the people. Okay? Governments are apt to be corrupt when they are not accountable. And if you can't hold them accountable because they don't recognize the rule of law, then you're put into an extreme situation. Now, one could say, after speaking with a number of the tribal members, that they are in that scenario as well. Okay, but it's our money that they're spending. And we don't know where it goes, because they're not accountable because they're quote-unquote sovereign. But Congress doesn't hold them accountable. The Department of Interior, with its Bureau of Indian Affairs, doesn't hold them accountable. And we are left holding the bag, all of us, as taxpayers. And we get to see these poor people, these poor tribal members, suffer at the hands of their own government, and they don't have full constitutional rights. They have an abridged Bill of Rights. Now, yes, tribal members can disassociate themselves from the tribe or acquire a fee simple title in a parcel of land, pay state and local taxes, and be a full-fledged American citizen, and be protected by all the Bill of Rights. But I don't believe, from what I hear, that that is something that they're persuaded to do. They're persuaded to stay among the tribal members and are peer pressured into doing so. Problem is they're not getting their full just desert. They're not getting the protection of the U.S. Constitution, which is an exemplar around the world. I've done a lot of international legal comparative analysis. The property rights here are negative property rights. They provide you as an owner with the ability to exclude others. That includes both individuals, entities, and governments from your property. Now, obviously, there are limits to that right of exclusion, and you must exercise your rights responsibly in order for the government not to come in and invoke a police power to curtail your activity. Now, these are negative rights, but in Europe and all of the colonies of Europe around the world, we have positive rights. Positive rights are subject to the will of the sovereign. They're conditional. They give you the right and they can take the right away. And it's up to them to decide whether your exercise of the right is in the public interest. And they usually weigh public interest over private interest. And I know this having been in the position, serving clients in international venue to encounter this, both with tangible property and intangible property, such as intellectual property. There is a trend globally to assert public interest, override over private interests. Okay? That becomes a national policy issue. And it involves all types of rights because it gives government greater control over the individual. Now, the European Union is in sort of a major quandary. Let's not even talk about its finances. It has very little accountability, those governments. But there is a democracy deficit, as they say, in Europe. Because they're in the stage of confederation of states when our states were before the Constitution. But they're in an effort to try to change that, but their whole culture and all of their property rights systems, their legal system, is very different. And they don't have that opportunity that we have. The effort of global governance is to make laws seamless across borders so that the large multinationals can transact business at the least cost possible. They're not beholden to any one country anymore as a home state, so to speak. They don't have that loyalty anymore. It's doing business, making profit, which is, in many ways, capitalism. But when you undertake and engage in capitalism and have control over the government or capture facets of the government to secure your own advantage at the expense of everybody else, that's not a win-win. That's a zero sum, and everybody else loses. Now, let's take the international and apply it here. The sovereignty of a federally recognized Indian tribe, dependent as it is on the congressional fisc and taxpayer money, is asserting itself in ways by being encouraged by the federal government to act for the federal government in some aspects. Federally recognized tribes can be treated differently by the federal government for different purposes. They can be treated as a state, for instance, for purposes of undertaking shared jurisdiction over U.S. navigable waters and airways. And EPA, the Environmental Protection Agency, treats tribes as states that they find eligible, which includes the CSKT. They help implement the Clean Air Act and the Clean Water Act for the federal government. They do it on the reservation. However, because of off-reservation hunting and fishing rights, the federal government has asserted that the tribes have the ability to claim quasi-title in water beyond the boundaries of the reservation, so they can regulate that water, even if it's not a navigable water. So what the federal government can't get to, if it's not a U.S. navigable water under the new Waters of the United States rule, they can get to through engaging the tribe as an agent of federal government. Okay, there is also tribal sovereignty at a local level. The Homeland Security Act of 2002, for purposes of its implementation, treats federally recognized tribes, which is a list that is published annually in the Federal Register. They basically treat them as a local municipal government. So depending upon the legislation, depending upon the government policy, the federally recognized tribe will be deemed a different type of sovereign. Now, what we learned with respect to the Kerr Dam is that the federal government has now treated the CSKT and its subsidiary, Energy Keepers, Inc., as extensions of the federal government, as federal instrumentalities for purpose of implementing both the Federal Power Act, which FERC has jurisdiction over, the Federal Energy Regulatory Commission, which is a part of the Department of Energy, which administers and enforces the operation and maintenance of dams and electricity rates, the setting of electricity rates. So they treat them as a federal instrumentality for purposes of the Federal Power Act and for purposes of the Public Utility Holding Company Act. And these statutes are not important for you to remember, but the general concept that a federally recognized tribe can be employed by the federal government in a legal fiction for purposes of achieving certain federal government policy objectives. But that does affect everybody's property rights in different ways. Northwestern transfers the dam and the infrastructure on the lands and the bottom lands to the river upon which the dam sits to the CSKT. The CSKT takes that title and would otherwise be subject to state and local taxes. But through an abracadabra trick that is acceptable in law, they can transfer the property over to the federal government for the federal government to hold it in beneficial trust for the tribes. And through that action, the federal government will not be subject to state and local taxes, as would the tribe have been. Another aspect of this is that federal instrumentality designation. The Public Service Commission of Montana has told me through their legal office that as a result of this transfer and the characterization of the tribe and EKI as federal instrumentalities for purposes of those two statutes, the Public Service Commission no longer has jurisdiction over the setting of electricity rates on the reservation. If you have any problems with the rates that the tribe charges, you have to go to the Federal Energy Regulatory Commission in Washington. Okay? So you can see now, at least the beginning part, of how a federal treatment of federally recognized tribes can impact your rights. Now, Elaine was absolutely correct that the federal government controls, owns title to all of the infrastructure on the reservation. The dam was the final piece of that puzzle. It owns now, because the tribes presented the dam and the infrastructure back, the lands back to the federal government, they own title to that. They also have owned title to the Flathead Irrigation Project. And they also own title to the transmission lines that are operated by Mission Valley Power in beneficial trust for the tribe. The tribe gets 638 contracts to operate the Mission Valley Power. They get a 638 contract to operate the project. And the irrigators, even though they pay for that project, are only told that they have to submit to the tribe's preferences on when the water will flow. Now in the Klamath, they refer to that level of the reservoir or the lake that can't be touched except when the tribe wants to let it flow through the gates as Endangered Species Act water. Okay, and there's good reason for doing so. The Kerr Dam license, the recent license, the 1985 license, had only a certain number of articles when it was issued in 1985 as an acceptance of the settlement that had been entered into between the tribes and the irrigation districts, the state of Montana, and the Department of Interior. Those articles were expanded, they were doubled in number during the course of the 1990s, not by FERC, which sat there as the go-to point that people thought would address their concerns, but rather the U.S. Fish and Wildlife Service of the Department of Interior was behind the curtain all the time, doubling the number of articles to implement the Endangered Species Act. Now, that does affect how and when water flows. It does affect lake level on the Flathead Lake. It does affect reservoir level on the reservoirs that capture the in-stream flow from the Mission Mountains. And it does affect your ability to grow during growing season. But the problem is, they had to craft a whole doctrine of water rights that is different than state appropriation water rights in order to provide the preference to the tribe of time immemorial and even 1855 priority. The tribe receives the benefit of first priority usually on the water flows. On the reservations due to the priority date of 1855 at the time the reservation was formed. For the in-stream flow, it becomes time immemorial Aboriginal right. Now in some case law in the West, the federal government refers to this Aboriginal right to fish and hunt off the reservation as Aboriginal title. So they start using terminology even though it doesn't reflect real title. And through osmosis and time, they hope that this new terminology, this new lingo, takes hold with judges who don't know what they're doing with respect to Indian policy and water rights. Now there was a case out there, the Abuselman case, that wasn't appealed, and it wasn't appealed for good reason. Because why make bad law if you don't have to? Maybe it'll just be ignored. Maybe other judges will be more enlightened and informed, so they won't cite it as precedent. But one of the things that I discovered, having been in the U.S. Supreme Court 2 weeks ago, sitting in an oral argument in a case of the name Sturgeon v. Frost, was that you are not alone on the Flathead in owning land surrounded by federal land. And you are not alone in having the federal government usurp your rights at the expense of federal rights, or usurp your rights for the benefit of federal rights. In this case, there were private lands and state lands surrounded by federal parks and economic conservation units within those national parks. And there was a hovercraft that was used by the private owner of lands that transcended those boundaries. And the federal government asserted rights to regulate the use of that craft and other types of activities. Well, on what legal authority did they do that? On the basis of Federal Reserve water rights. Now, Federal Reserve water right, at least to most people who understand water rights, is a usufructuary right, as they used to say in the common law, or a use right. It's real property in Montana, but it's still a use right. There are all types of property, forms of property, levels of property ownership. This is merely a use right. The federal government treated this use right as quasi-title. It was an aboriginal title, as a way to flip the balance in the favor of the tribes. I mean, that is part of federal Indian sovereignty policy. There are executive orders, a number of them from a number of different presidents, that basically state that federal agencies are supposed to bend over backward and be flexible in implementing federal requirements when dealing with federally recognized tribes. Every agency must have a policy to this effect. And we do have the documentation to back that up. But the point here being, through this case, Sturgeon v. Frost, 8 of the 9 U.S. Supreme Court justices proceeded to question the Solicitor General of the United States as to how he can take a usufructuary right and convert it into title, which would enable the federal government to regulate. That's effectively, essentially occurring with EPA. Treatment of states basically takes an off-reservation right to hunt and fish, which does not give you any right to use the water. I mean, you get to use the water in non-consumptive fashion. And it converts it into a quasi-title from which the tribe can regulate on behalf of the federal government. That includes ambient air and in-stream flow. And that in-stream flow and ambient air ultimately will affect off-reservation property and the owners of that property, including yourselves. The Department of Interior Fish and Wildlife Service does the same thing. That's where the ESA water comes from. In Klamath, just like here at Flathead Lake and in the reservoirs on the reservation, the water levels stay at a certain level, and or they are let flow, or they open the gates and the water flows through just when you need it. And it's to serve the cultural and religious values of the tribal government. And it is not in the interest of the irrigators. They're picking favorites, in other words. These are preferences. And when you have a preference, usually, in favor of one type of race, creed, color, or people, and in favor of another, when you favor one over another, you have a constitutional issue. It tends to be a discrimination issue. But under federal Indian policy, a memorandum that we have found since the 1960s, if the federal government engages in policy or enacts legislation that favors federally recognized tribes, that is not considered a fatal discrimination. Okay, when you have discrimination, usually you have a level of strict scrutiny, wherein the federal court will evaluate the government activity, the law, or the implementation of the law, or the regulation, and require the government to justify the law as enacted or the law as implemented. But with federal Indian policy, they've come up with the notion of benign racial discrimination. Benign racial discrimination is subject to a lower standard. It's called rational basis review in constitutional jurisprudence. And rational basis review only requires the federal government to show a relationship between, a tenable relationship between the policy and the outcome. That's all they need to show. So guess how many laws have been struck down in favor of the federally recognized tribes? None. Very few. So, with these types of preferences also come regulatory waivers, as I mentioned before. The agencies are to interpret the regulations as flexibly as possible to accord sovereignty to the tribes. But what is the outcome to third parties? Now, with the transfer of Kerr Dam, one of the issues that we saw that was a problem was that the dam was being acquired by the CSKT, but the acquisition rules of the Federal Power Act, which FERC administers, were waived through this designation as a federal instrumentality. Okay, so it was almost as if FERC had anticipated that the tribes would then transfer the dam back to the federal government. But those steps were skipped. And as a result, nobody was provided, the public was not provided with any accountability as to whether the tribes were worthy, capable, and able to service and operate the dam in the same way that it had been serviced and operated before. Another aspect was safety record. There was no record of safety following the year 2012. And if you went through the FERC administrative website to see if there was any information concerning the safety inspections of the dam, or if you were wondering whether the operators of the dam, the licensees, had engaged in information exchange with the Department of Homeland Security for national interest purposes, national security interest purposes, all of the designations on the FERC website were classified national security. You couldn't get to that information. Now imagine, Kerr Dam is a Category 3 hazard dam. It starts up without the electric grid being on. It's got water power, it doesn't require electricity to start. But it's a Category 3. And it's only half the size of Hungry Horse Dam, which sits above it. And that dam, I happened to be able to walk beside last August, and we didn't see any security people. And that dam is within 50 miles of the Canadian border. Now I'm told, after speaking with my clients, that there is no security at the Kerr Dam, at least any visible security. Maybe they hide behind trees, I'm not sure. But there's nobody there. So who's watching the fort, so to speak? And we are in an era which is beyond our wildest imagination, where we have open, porous borders with all types of criminals, refugees, and even terrorists walking across, and there's no accountability. Now, if the tribe is going to assume management and control and ownership of that dam, it is the responsible party, unless the fiction is put in place. It's really the federal government that's operating it, and the federal government's not accounting to us because it doesn't want to let us know who's coming across the border. It may have other designs in mind. So where's your accountability? The whole notion of the administrative state, which we are now experiencing, was that there was a quid pro quo of accountability and transparency to the people in exchange for letting the government grow. We don't have that accountability and transparency right now, and federally recognized tribal status makes it even less so, because they don't answer to anybody because they're not subject to the U.S. Constitution. The tribal governments do not believe they are subject to it. They believe they are foreign entities. And if we have 566 foreign entities within our U.S. national borders, how do we have a protected nation? One of the things that we had placed in our lawsuit in September was that there were efforts by the government of the Republic of Turkey to make relationships with the Native American community in the United States. We found, because the tribes had boasted about their trip to Istanbul in November of 2010, that 17 of them were selected by the government of Turkey for this trip, all expenses paid. And the ostensible reason for this was cultural exchange, business exchange. Because when you go through another aspect of this, which will, I think, raise your eyebrow, it was Congress's intent to put these two groups together, or at least to follow the wishes of the Turkish government to do so. Now, with all truth, Department of Interior's reservation leasing policy was highly cumbersome. You couldn't get a lease through the review of the Department of Energy Bureau, the Department of Interior Bureau of Indian Affairs. It took quite a while. Whether that's because of the capability of the bureaucrats or just because of the technical complexities of a lease transaction, I don't know. Some of you in the real estate business might realize that leases are usually not that complex. But the government always finds complexity in simplicity. And that I can tell you from experience. So, in addition to the leases taking a long time, reservations don't seem to get a lot of foreign direct investment as other foreign nations might get. And that may be because the laws that are used to govern the transactions that businesses would enter into with tribal entities are not U.S. laws, they're tribal laws. There is a doctrine of tribal exhaustion that the federal courts have developed over time. It's nowhere found in the Constitution, but it's found in the jurisprudence as enforced by this tribal sovereignty policy of the executive branch, whereby federal courts will defer to tribal courts on most types of disputes between tribal members or tribal entities and non-tribal persons or entities. U.S. businesses are not interested in investing on reservations because they can't get certitude as to what the transactions may end up looking like. They don't know that if they have a contract dispute, they will be justly represented. They don't know if they will have a predictable outcome. Certainty and predictability in business transactions is key. So U.S. businesses usually don't engage on reservation. They engage outside the reservation's borders. So that denies the tribes a lot of revenue that they otherwise could get. So enter stage right, here comes the Republic of Turkey looking for new business opportunities. And they also seem to have a cultural affinity with and similarity to the Native American tribal cultures, as they said. And this is in the colloquy of Republican Representative Cole of Oklahoma, sole Native American representative in the U.S. Congress. He was approached by Turkey in 2011 with a request that he introduce a bill that would permit the leasing of reservation lands for up to 75 years to Turkish enterprises for cultural, business, agricultural purposes. And that bill, in the colloquy, was justified because of the common cultural ancestry that the Native American tribes had with the nomadic culture of Turkey. As it was stated in the colloquy, as I recall, the Turkish representative had said that both had suffered at the hands of the European settlers. They could identify with one another. That's not a good beginning. But that bill didn't go anywhere, really, because people were concerned that Turkey, even though it was on paper a NATO ally, they were concerned that Turkey wasn't as reliable as they once were during the Cold War. So another bill was introduced by a representative from New Mexico. And that bill was much more expansive than the Turkey bill because it included all 566 tribal entities, tribal sovereigns, and was available to any party, domestic or foreign. And as long as the leasing regulations of a given federally recognized tribe passed muster with the Department of Interior, each individual transaction would not be scrutinized. And there would be no accountability as to who was leasing land or buildings on these 566 reservations. That bill almost passed unanimously in the House and Senate. Your representatives, both Republican and Democratic, bought into that. Okay? So, you have your sole congressman, Ryan Zinke, a war hero, member of SEAL Team 6, fought, I think it was in Afghanistan or Iraq, guarding the front door against terrorists. But he voted for the leasing law with an open border policy, knowing full well what might happen. And the question is he guarding the back door? You have Senator Daines, another Republican, who did the same thing. You have Senator Tester, and you expected him to do that. And then you had your former congressman, I think it was, the former senator, also did it, who now became a lobbyist, who has since become a lobbyist. I need not mention his name because he's well recognized. But the fact is, who's watching the henhouse? Okay, amidst all these types of activities. If the federally recognized tribe of the CSKT was to assume its full responsibility as a sovereign entity, then it would speak up and ensure the population of this reservation and those surrounding it that it has things under control. But I haven't seen any evidence of that anymore. Have you? I don't think so. And the Department of Interior has not required it either. They are bereft in fulfilling their responsibility to the citizens of the state of Montana. And with respect to all 566 tribes and the 326 reservations, among them, what has the federal government done to assure anyone that they are watching out for them? No, the White House would rather go in and apologize in a mosque to talk about how there's discrimination against Muslim people. But he won't talk about the discrimination in favor of federally recognized tribes. It's a form of affirmative action. That's why he won't speak about it. And we'll just leave it at that. The point is that this type of sovereignty is not in the interest of those who are not tribal members. But let's speak again. We're distinguishing between the tribal governments and the tribal members, because the tribal members are not even protected by their own councils. They're abused by their councils. It's amazing how easy it is for the social services people to come in and separate families in tribal districts. It is easy to see how employment can be terminated, not merely at will, but as punishment for speaking out and expressing their right of free speech. That is unacceptable in a nation with a constitution like ours. And the CSKT should be ashamed of itself for not respecting that constitution, of which it is a part, supposedly, as a sovereign nation within the United States of America. Now, what could it do? It could recognize the rights of its tribal members and give them the freedoms afforded by the Constitution. But it chose not to. It signed on to the Indian Reorganization Act, which had a truncated Bill of Rights. It's not compelled to provide those rights to its own members. The federal government walks away from it in the interest of honoring the sovereignty of the tribe. Now, the CSKT is the first Indian Reorganization Act tribe. It is held out as an exemplar among the 566. So whatever it is permitted to do, the others will ask for. It's a simple equation that the government has made quite complex by covering it up in layer upon layer of excuses, waivers, exemptions, and preferences. Now, the problem we have with water rights is just one example of that. It extends to land rights. It extends to your ability to get due process of law on reservation, and now they're trying to expand the notion of due process under tribal law beyond the boundaries of the reservation to include non-tribal members. It seems to be a continuing, ongoing push to expand sovereignty at the expense of all other American citizens. Now, tribal members are also American citizens, but the tribal government seems to usurp that right. In the name of sovereignty, it denies those citizens the rights to which they're entitled. And they do it also because of this notion of global governance, which respects the rights of indigenous peoples to have all of their aboriginal lands and waters restored around the world. Why not just erase 200 to 300 years of history? Why not accept the fact that things change? They don't wish to accept that change. They wish to change it back to the way it was before the world was settled. That makes no sense. But they have federal protection because the feds benefit from the designations. If the feds can't get to a waterway because it's not a navigable waterway, which they can regulate, they go through the tribes to find the off-reservation fishing or hunting right. And they get to extend their jurisdiction by using the tribes. The tribes enjoy being used because they get lots of money and benefits. The CSKT is no exception. They have billion-dollar contracts with the Department of Defense. If Turkey is engaged in activities that are contrary to the national interest, which they have since been shown to be, and which former administration officials have come out in the public to testify before Congress about, this White House ignores it. And the tribes under White House administration, through implementation of the laws on behalf of federal policy, also ignore it. Turkey is not a reliable NATO ally. It's been shown to be. There's documentation to this effect. But the tribes wanted to give effect to Turkey's extension of friendship, to engage in leasing transactions on reservation. The Turkish delegation was in your state capital in 2015. You had exhibits there of cultural exchange. You have children from Montana, from the tribe, going and going to school in Turkey, and students from Turkey coming here. This is more than a business opportunity. This is more than coincidence. Our nation has a nuclear cooperation agreement with Turkey. Turkey is insistent upon developing its civilian nuclear power, and we entered into an agreement with them during the Clinton administration. In 2000, before the ink was even signed, the government of Turkey was caught cheating with the government of Pakistan, trying to obtain fissile material. It was also, for that reason, that agreement was held in abeyance by the Bush administration until the latter part of 2008, when, after due diligent review, they finally signed off on that agreement. But Turkey, in other venues, have asserted the right, the inalienable right, to reprocess nuclear fuel, to enrich it. And they did actually defend the government of Iran in the nuclear supply group, which also claimed that right. There's a lot going on here. There's a whole lot of dynamic that is not spoken about at the federal government level, and because the tribe is serving the national government's interest, they're not talking about it either. We had to raise this as part of our lawsuit because we needed to show an emergency. It is an emergency. Fortunately, nothing bad has happened yet. Because you know why? The government really is behind the scenes controlling what's going on but not telling anybody. But that doesn't give us any reassurance because the government is also letting all the refugees come in the borders, and recent reports indicate that they are flying them in through charter flights. There are state governors that would rather not have refugees come in because of their associations. I mean, Turkey is known and has been documented to harbor terrorist groups. They are known and have been documented to facilitate ISIS as we have. It has been documented and it is known that the Muslim Brotherhood is advising White House policy. It is known and is documented that the Muslim Brotherhood also is being harbored by Turkey. Prime Minister Cameron of the United Kingdom recently declared the Muslim Brotherhood a terrorist group. We had previously declared them as a terrorist group. They were responsible for what happened in Egypt. But our government has looked past that and has come up with excuses as to why they're not investigating. But the point is that the tribe, as an instrumentality of the federal government for purposes of this Kerr Dam, followed suit. They didn't look into it. And for that reason, we should all be concerned. Again, you've got two major dams. When you sequence them and open the gates at approximately the right time, you will get a lot of water. That water is used to generate a lot of electricity, and oftentimes that water just flows through and you all don't get it for irrigation purposes. Yes, there's Endangered Species Act water in there, but there probably is other water in there that may be transported outside of state for other reasons. You are the jewel of the Nile, so to speak, in the West. You've got abundant water resource that is worth trillions of dollars. There is a reason why the federal government, through its many forms, is controlling the infrastructure for which the water flows. There are multinational companies out there acquiring companies that have rights to water, access to water. They're acquiring governments, municipal governments with rights to water. Water is the new gold. And where there is shortage of water, the feds wish to be the arbiter of that or delegate that responsibility to sovereign, federally recognized tribes. The CSKT Water Compact is a bad deal. It changes appropriation water law in this state. It shortchanges you to what you are entitled under your claims. It predates most everybody's rights, and however, there are those who have pre-1855 rights that should make a call on the water just to show the government that it can't do what it wants. And through this new mechanism to administrate water claims on reservation, they take it out of the hands of the water court, which your legislature 40 or 50 years ago thought should be the arbiter of competing water claims. That denies you due process. And it's for the benefit of the tribes at the expense of you all. Whether you're willing to accept that is all up to you. We came into Montana because a friend of mine, Robert Fanning, asked us to come in to try to help out when the legislation for the compact was being passed through the legislature in the spring of 2015. Yes, there are problems with securing Montana lawyers who have a position against that compact. There are conflict of interest issues because in a small state such as this, where everybody knows everybody, it seems, that many or most of the good lawyers are representing either the state, the tribe, or some other instrumentality that has an interest, including especially the utilities that have an interest in the outcome. And it's really difficult to find an objective attorney that can take the polar opposite position because it would endanger their business. There are two types of conflict. There's a conflict of interest with respect to the same client, and then there is something regarding positional conflict. You can't take an adverse position to another position, to the position of another client on the same or similar matter. So I've also encountered this out in the Klamath region. They've told me that they can't find lawyers in Oregon and California, Northern California, to take on a lot of this, and those that have burned through a lot of money and haven't achieved much of an objective. It's almost as if they were placed there intentionally to draw down resources so that the irrigators couldn't fight another day. That's a tragedy. So, I'm here to try to help you all, and my team of Elaine and Wendy, and the clients we have acquired, and our support team, including Clarice and others here tonight, are very helpful in helping us get out the word. Because you have to look at these issues not as separate silos, as have been up to date, as they have been looked up to date, but you have to look at them as interrelated issues. Okay? On the one hand, you have federal Indian policy. On the other hand, you have water rights policy. On the other hand, you have federalism policy, the dynamic between the states, the feds, and the local governments. And then you have international policy, and international law that is arguably being invoked to support, as legal authority, the actions of the federal government to come in and take control of the water infrastructure through creation of legal fictions on Federal Reserve water rights. There's something known as a War Powers Statute. War Powers Act tracks back to the Lincoln era. There's something known as the Lieber Report, which was basically the first codification of the laws of international war to be used by Union soldiers during the Civil War. Interestingly, one of the provisions in that Lieber Code, which ultimately served as the source of the Geneva Convention and declarations before it in Europe for European laws of war, was the prohibition against the destruction of property unless it was absolutely necessary. Now that's in real war, where you don't have real war, but you have a legal fiction of war through a statute. Then it's interpreted slightly differently. Arguably, this federal government is invoking a war power statute that dates back to the Civil War to claim absolute authority to provide preferences to the tribes in terms of water rights, to control the infrastructure without giving you a say-so in any of this. Because there's a legal fiction of wartime. You're still at war with the tribes. And the tribes benefit from this because of all the give-outs. They're not apt to talk about it, but it's there. And part of the challenge in bringing this up in a legal proceeding is that the judges, the courts, are not aware of all this. This is recently uncovered information. And the question is, what were they up to? They were revising American history, it so seems. You've got a multi-layered onion here, and it's not smelling too good. And it doesn't provide much hope unless you try to deconstruct all of the components and place them in their proper order. The order of the nation, based on a constitutional framework that is unlike any other constitution of any government in the world. If you look at the governments of Europe, they continually revise their constitution. Asia, they revise their constitutions. It's almost as if it's a statute enactment exercise. People who call for constitutional amendments here should be wary and should be very cautious in calling for amendments, because the ability of this Constitution to endure as it has been because, not for the opportunity of amending it, but rather the ability to interpret it. it is inherently flexible, but not flexible to the point of breakage. It takes into account the modern without forgetting the past. And that's why the Supreme Court is careful. Sometimes it makes errors, just like the rest of us, in changing the jurisprudence too quickly to reflect winds of public favor at any moment in time. Now, I'm sworn into the federal courts of the District of Columbia, starting with the federal district, the appellate court of the District of Columbia, and the U.S. Supreme Court. I take my job seriously. I take my oath of office to the U.S. Constitution and not to any president or congressman seriously. The problem we have now is that there seems to be an oath to a person, not to a constitution. The rule of law is being replaced with the rule of men. This is precisely what the founding fathers sought to avoid. If you go back in history, they evaluate what the laws of Europe were at the time, and they saw devastation. They saw servitude. They were inclined, they were determined not to have the same mistake occur here, but they were also aware that humans are fallible beings. And over time, greed takes over. And as best a system as you can develop, people will assume control and distort that framework. Use it to their advantage. The question is, how do you keep on regenerating that framework without destroying it? How do you hold the people who serve in office accountable? You can do it through the political process. You can throw the bums out of office and start anew. Maybe there is some wisdom to imposing term limits on the Constitution, which might be a worthy constitutional amendment. But there are pros and cons to that. Whenever you have an amendment proposal, you always need to look at the pros and the cons. Okay, so you have the political process. You also have the judicial process. Now, the judicial process has gone off the rails as well because Congress has left a great void in reviewing the laws it once enacted. Congress enacts a law that broadly delegates authority to the executive branch to fulfill the legislative mandate. And sometimes that legislative mandate's not even clear. And because of the void, the courts come in when you have technical issues and defer to the federal agencies. They refer to this deference as Chevron deference pursuant to a case from 1984, National Resource Defense Council versus Chevron. And basically, courts will defer to the expertise of a federal agency as a matter of course, unless the litigant can prove that it's unjustified, that they acted in an arbitrary, capricious manner. And when you deal with science and technical issues, it becomes a double deference. They must, in the court's eye, defer to the agencies because the courts don't want to step into that quicksand. And guess what? That whole doctrine was developed by Republican Supreme Court justices, appointed by Republican presidents. The whole notion of Article III standing, Article III being the federal judiciary, of Article III of the Constitution, and the role of the courts in the balance of power. The doctrine of standing basically acts as a bulwark against frivolous lawsuits. You need to be injured in fact in order to bring a lawsuit. You need to have proof that Congress intended that you were one of the parties to be protected by the law that you're citing as authority. And you have to show that the court's engagement in the lawsuit, the acceptance of the lawsuit, would result in a different outcome. Simple explanation. It's obviously a bit more detailed than that. But to suffice it to say that Article III standing has been used mostly by conservative justices because they were concerned about all of the lawsuits that were brought by the environmental community against the executive branch during a time beginning with the 1980s. So they were protecting their Republican executive branch sponsors in a way. But anyway, this can get really detailed and it can become very boring. But suffice it to say that the framework is in jeopardy. It needs to be regenerated. Federally recognized tribal sovereignty does not help it one bit. It actually places in greater jeopardy. And the CSKT Water Compact, because of its alteration of state water rights and its denial of due process as would be provided by the courts, places everybody here in jeopardy.